There are various options available for graduates of high schools across the United States. Some of them choose to go to college or university, but even making that choice gives you a lot of options. There are basically two categories of schools, though, that I want to address in this statement this morning. One category is called for-profit colleges and universities, and the other is the traditional not-for-profit college and university. That would include your community colleges and public universities and many not-for-profit private universities. But I want to focus in this morning on the for-profit colleges and universities in the United States. People sometimes can't make the distinction, which is which. Some of the big names in the for-profit industry: University of Phoenix, there's one you probably heard of. DeVos University out of Chicago is another one you might have heard of. There are some defining characteristics of these schools. They, of course, are in business to make money, and they have a different economic model than many of the other universities. I've met the CEOs of for-profit colleges and universities and found that in some cases they have limited or no experience when it comes to education. They're investors, they're business people. The idea of education is a secondary part of why they were chosen. There's an important statistic, in fact, two statistics, that I want to preface my remarks with. And these will be on the final, I might add, for those who are following this statement. The numbers 9 and 33. 9 and 33. Why are they important? 9% of high school graduates go to for-profit colleges and universities. 9%. But 33% of all the student loan defaults in the United States are students from for-profit colleges and universities. 9% of the students, 33% of loan defaults. What's going on here? Well, what's happening here, unfortunately, is that many of these students who are signing up for the for-profit schools that they think are legitimate colleges and universities, frankly, dramatically overcharge them. Every analysis we've gone through says the tuition at these for-profit schools far exceeds what students are likely to pay, certainly at a community college and in the case of many public colleges and universities. So they have a big tuition bill to start with, and they have poor results. What kind of results? Students graduating, believing that they are being trained or educated to do a certain profession, and then they find out that they can't do the job, or they don't qualify for the job. Or they get so deeply in debt on the way to graduating, they give up and quit, the worst of all possible outcomes. So that's the preface on these for-profit colleges and universities. I've come to this floor many times over the years to talk about this industry because we treat it, in the eyes of the public, like higher education across the board. And yet it is much, much different. It is for-profit as opposed for not-for-profit. And frankly, the results of that education leave a lot to be desired. It's been more than 5 years since the for-profit giant Corinthian College collapsed. Their economic model didn't work. For years, Corinthian had lied, inflating its job placement rates and engaging in high-pressure tactics to lure students into enrolling, often leaving them with massive student loan debt and a diploma that didn't work to find a job. But Corinthian was not unique. As I've said many times, it turned out to be the canary in the coal mine. Since Corinthian colleges, we've seen the collapse of several other major predatory for-profit colleges and universities. They include ITT Tech, Westwood, Education Corporation of America, and Dream Center. And nearly every major for-profit college company has been the subject of extensive investigations and lawsuits for unfair and deceptive practices similar to Corinthian College. Check with the Attorney General of your home state about that for-profit college and university, and almost without fail, you'll find that they're under investigation for misleading and deceiving the students who go to school at their universities. I've long said that we shouldn't let the students, leave the students holding the bag for the misdeeds of these institutions because, you see, we're complicitous. The federal government is part of the problem. How do these schools reach the point where you can take out a federal student loan? We accredit them. We recognize their accreditation. We tell the world and the families and the students, these are legitimate schools. And depending on that, these students sign up for a bitter experience, often misled, deceived, overcharged, and ultimately a third of them in default on their student loans because they can't pay them back. There's a provision in the Higher Education Act known as the borrower defense. It gives the students the right to have their federal student loans discharged by the Secretary of Education if they've been defrauded, if these students have been defrauded or subject to deception by these schools. After Corinthian's collapse, this little-known, rarely used provision in the law became a hot topic. All of a sudden, here were large numbers of students who had been defrauded and deceived by Corinthian colleges, went deeply in debt, and now the college goes out of business. Turns out most of the hours they took can't be transferred anywhere. It's worthless. They were defrauded start to finish. And now they're left holding the student loan bag. Thousands of Corinthian students and other borrowers, mostly from for-profit colleges, began applying for this borrower defense discharge from the U.S. Department of Education. It was in the law. It led the Obama administration to undertake a new rulemaking to update the borrower defense regulation, which dated back to 1994, to create a standard process for dealing with the inundation and to attempt to prevent future collapses. Soon after taking office, Secretary Betsy DeVos in the Trump administration delayed implementation of the Obama rule, despite the department's own Inspector General saying that implementing the rule would, and I quote, avoid costs to students and taxpayers that result from school closures. Secretary DeVos said, I'm not going to be party to that. They took her to court. Her decision to delay this new rule was found illegal by a federal judge, after which a new rule went into effect, and it remains in effect to today. Secretary DeVos also announced she would begin a new rulemaking to replace it. In late August, Secretary DeVos released her borrower defense rule, the new rule, which she wants to put in place. It actually guts the borrower and taxpayer protections in the borrower defense rule and makes it nearly impossible for students holding this student loan debt who have been defrauded to get relief. How does she make it so hard? It's estimated the rule will provide $11 billion less in relief to defrauded borrowers, students, than the current rule. Among other things, the new Betsy DeVos rule increases the burden on these defrauded students to gather and submit almost impossible amounts of evidence to somehow prove their claim. Student borrowers will have to provide evidence that the school intentionally harmed them. Now, how are they supposed to do that? The DeVos rule, the new one, requires borrowers to apply individually rather than receiving automatic discharges when they're part of a group of student borrowers that's been harmed by similar practices by places like Corinthian. In other words, you're on your own. Get your own lawyer. Lawyer up, get some evidence together, come see us, and maybe we'll be convinced. Student borrowers who've been cheated are not exactly the wealthiest group in America. They're often facing incredible financial difficulties and deep emotional strain with a mountain of debt and nothing to show for it because of these for-profit schools. And now Secretary DeVos wants them to be investigators and lawyers and get their own relief one by one. The DeVos rule also eliminates the current prohibition on class action restrictions and mandatory arbitration clauses in enrollment. What does that mean? Under the current rule, which Secretary DeVos wants to replace, you could gather the other students from Corinthian colleges and work on this together. Share whatever expenses there might be involved in proving your claim. And you couldn't be forced into an arbitration where you're likely to lose. You could have your day in court under the rule which Secretary DeVos wants to replace. These are practices that were used by Corinthian and ITT Tech and others that required students to sign away their rights to sue the school as an individual, as part of a class, or as part of a class as a condition of enrollment. The DeVos rule prevents students from holding schools directly accountable for their wrongdoing and seeking financial redress through the courts. It gives students no other option than to seek relief from taxpayers through borrower defense, but as I just mentioned, makes that process almost impossible. And if anyone doubts the devastating effect this rule will have on the defrauded student's ability to get relief, just look what Secretary DeVos has done to date. Since taking office, Secretary DeVos has had the authority to discharge hundreds of millions of dollars in student loan debt held by hundreds of thousands of defrauded student borrowers. Instead, she's allowed a backlog of more than 200,000 borrower defense claims from virtually every state in the nation, student borrower defense claims coming from all 50 states to build at the department. She's sitting on it. She's playing slow ball. She's not approved a single claim, though 200,000 are pending. She's not approved a single claim in more than 1 year. And here I want to show you what's behind this. In the few cases where Secretary DeVos has been legally required by the courts to provide discharges, she's done so with extreme displeasure. Quite different. Think about that. Using her authority to help defrauded borrowers get a fresh start brings her extreme displeasure. How do I know that? She wrote it. Here's one of them. Recommendation to discharge. She approves it, signs it, puts down as a comment with extreme displeasure. Discharging a student loan from an institution, for a profit institution, that defrauded this borrower. She's displeased to be forced to do such a thing. She defied a federal court order, was held in contempt for continuing to collect from these students who've been defrauded by Corinthian. This is not a secretary who rewrote the borrower defense rule to help student borrowers. In September, I introduced a resolution in the Senate to overturn the DeVos borrower defense rule. 42 of my colleagues have co-sponsored it. I plan to bring the resolution to a vote on the Senate floor, where it will only need a simple majority to pass under expedited procedures of the Congressional Review Act. At that time, my colleagues will have a choice. Will you stand with Secretary DeVos or with the defrauded student borrowers in your state? What do the American people think about this? Well, they were asked. There's no doubt where they stand. In a 2016 New American poll, the question was asked whether Americans agree that students should have their federal student loan debt canceled if their college deceived them, exactly what the borrower defense rule is all about. 71% of Republicans said yes. 87% of Democrats, on average, 78% of Americans understand it's fundamentally unfair to penalize these students having been defrauded by a school that this United States government said was in business, doing business honestly and professionally. When you break the numbers down, it's clear. The overwhelming majority of people in this country stand by the students, but not Secretary DeVos. I'll stand with the defrauded students and the American people over Secretary DeVos, and my colleagues in the Senate will get a chance to vote on it. I hope my colleagues will join me.